Thank you to everybody for joining us today. I am Sarah Hart, a partner in our Edmonton office, co-lead of the Denton's Professional Liability Subgroup, and member of Denton's Litigation and Dispute Resolution Group. My practice focuses on commercial litigation, professional liability, as well as shareholder disputes before all Alberta courts and tribunals. Today, I am joined with three of my colleagues. Firstly, Deepshika Dutt. Deepshika is a partner in our Denton's Litigation and Dispute Resolution Group and co-leads the firm's National Professional Liability Subgroup. Deepshika regularly defends auditors, accountants, and other professionals in liability claims, regulatory investigations, and complex class actions. Deepshika is known for her courtroom strength and practical counsel, with extensive experience handling matters involving alleged professional negligence, misrepresentation, and regulatory breaches. Secondly, Christy Lee. Christy is a partner in Denton's Litigation and Dispute Resolution Group with significant experience defending professionals, including auditors and accountants in regulatory and liability matters. Christy regularly represents professionals before their regulatory bodies, including before the Chartered Professional Accountants of Alberta and at all levels of a court in Alberta. Christy is known for her pragmatic, business-minded approach to resolving complex regulatory and professional liability disputes. And finally, last but not least, Michael Schaeffler. Mike is a partner at Denton's with nearly 30 years of experience handling complex commercial litigation and arbitration. He has particular expertise in auditor liability, financial services disputes, professional negligence, and securities litigation. Mike is frequently retained in high-stakes matters involving accounting firms and is recognized for his strategic approach to resolving complex financial and regulatory disputes. So that is our panel for this morning. So without further ado, we will start with our table of contents, and we're going to take you through 4 areas today. The first being the evolution of auditor liability, focused on 2 main areas, the scope of the duty of care in case law, and the developments and applications of the duty of care since the Livent decision. Secondly, the key area of managing your regulatory risk. Again, 2 sub-focuses. Firstly, dealing with CPA Alberta and other regulatory bodies, and secondly, what to do and not to do. Thirdly, the status of the rectification doctrine in tax liability. What is the current law? Where are we at today? And finally, practical and strategic considerations for you. What to do when your civil, criminal, and regulatory risks all collide and are paralleling each other. And secondly, the application of limitation of liability clauses in engagement letters. So if we could move to our first topic, and I would like to first turn to Michael Schaeffler. And Mike, I'm hoping that you can take a few minutes to walk us through the history of auditors' liability and where we currently stand.
Thanks, Sarah, and welcome everybody. Again, pleasure to be here today. I'm going to focus on 4 cases. Some of them are a little bit older, and then culminating in the Livent decision, which now already is almost 8 years, actually is 8 years old itself. But it's important, in my view, to understand the evolution of accountant liability / auditor liability so that one understands precisely where the risk lies today. You have to understand the history in order to understand what the present day is really all about. And there are 4 cases that have shaped this landscape. And you'll probably have heard of them. They're the Ultramares case, which was decided in 1931 by the New York Court of Appeals. The Hague and Bamford case, which was decided in 1976 by the Supreme Court of Canada. Hercules Managements, which was decided 20 years later by the Supreme Court of Canada. And then yet another 20 years later, you see the cadence here, the Livent case. And what's also interesting about these cases is if you ever printed paper off still, or if you just looked at it, you would see that the Ultramare's case is quite thin. And you would see that the Hague and Bamford case, also very thin. Then you get to 1997, and you have Hercules. That has 65 paragraphs in the analysis. And then the most recent, the Livent decision, which spans 178 paragraphs. And curiously, the courts over the years have said that the accounting profession has become more complicated and complex, and it seems, therefore, so too have the reasons for explaining when duties of care have been imposed. So, very easy to start with what Justice Cardozo held in 1931 on behalf of that court. There was a concern, and remember, that was ironically about the same time that the famous snail in the ginger beer case called Donahue and Stevenson was penned by the House of Lords, which established a duty of care in tort. And yet, at her about the same time, a duty of care for the tort of negligent misrepresentation was eschewed by the New York court in those famous words that you see there on the slide that have been quoted over and over and over to this very day, that if you ding an auditor, or actually if you ding any professional for a statement and hold them liable, you could expose them to liability in an indeterminate amount over an indeterminate time and to an indeterminate class, because, so the concern was expressed, that opinion would be put out there in the ether and anybody might rely on it. And so back in those days, the answer to that was, well, there won't be a duty of care for negligent misrepresentation. You can sue for breach of contract if you're the audit client, and you can sue for fraud. So the law, of course, evolved, and we have Lord Denning to thank really for the current state of the law, I would submit. He penned a dissent in the mid-1950s that the House of Lords then picked up in the famous Headley-Byrne case, which then in turn the Supreme Court of Canada picked up in 1976 and said, well, wait a minute, not so fast. These concerns over indeterminacy can be overcome if we have the appropriate guardrails. And what happened in that case was that an investor relied on a financial statement prepared there by the accountants. And it turned out that the statement had been incorrectly prepared and the investor lost some money. The auditor or the accountant preparing the statement knew at the time that the company would be taking the opinion and giving it to a limited class of investors. And so based on those facts, the Supreme Court wrote there, Chief Justice Dixon wrote what you see there, that the nature of the transaction was known to the accountants. And that's an important one, just pausing there to this very day. The purpose for which the statement is prepared and the use to which it is put must be perfectly aligned. Then the second piece is that the accountants were aware that the company intended to supply the statements to a limited class. So that dealt with the knowledge, so reasonable foreseeability, basically, and the limitation that not the whole world was going to get this, but only a targeted few, and it was known what the total investment was going to be, and so therefore the indeterminacy with respect to amount was covered as well. And so that was the statement some almost 50 years ago now by the Supreme Court of Canada that held the accountant liable in that case. So Fast forward another 20 years and fast forward to the next slide, and we get to the Hercules case, which is, I've summarized some of the excerpts at the top of the page. So what had happened? First of all, the English House of Lords had adopted the ANS test, if you remember that the Supreme Court of Canada had adopted in the city of Kamloops case later. And it was that two-part test that you see here. Basically, a prima facie duty of care was the first part of the analysis, which consisted of reasonable foreseeability and reasonable reliance. And then the question whether there were any policy considerations that negatived any prima facie duty of care. And the policy considerations were basically taken from Justice Cardozo in Ultramares and had to do with the purpose being misaligned. Now, I'll just come back to that in a moment. And so in the Hercules case, this was a proposed action by shareholders. And the gist of the complaint was that the shareholders had lost their investment in the company because the auditor had misstated the opinion with respect to the financial statements, which did not present fairly in all respects. And the Supreme Court of Canada found that the foreseeability criterion had been met, found that reliance would have been reasonable in the circumstances, and so established a prima facie duty of care, but then concluded that there was a problem with respect to indeterminacy. And the reason was this: the audit was a statutory audit done to comply, in that case, with the Manitoba Business Corporations Act, but that same thinking applied across Canada to any other similar corporate type statute. And the purpose of a statutory audit, according to the Supreme Court of Canada, is not to guide individual investment decisions of shareholders, but rather to allow the collectivity of shareholders to oversee management. And I want you to remember those words for a moment, because I'm going to submit to you that something strange happened in the next 20 years. So that was Hercules. No duty or prima facie duty of care negatived, because a statutory audit cannot be used for the purposes of informing personal investment decisions. So then you come to the Livent decision, and the way the Supreme Court recast the test. The Supreme Court said, well, we understand that the ANS test no longer exists. The House of Lords abolished it in 1990, but we decided we would continue with a Canadianization of it, which manifested itself in the Cooper case and the Law Society, Edwards and Law Society of Ontario cases, where the test was recast so that these policy considerations would in fact form part of the proximity analysis in the first part of the prima facie duty of care analysis. And you don't get into any policy concerns per se if in the proximity and foreseeability analysis you have, again, perfect alignment of purpose and use, and of course knowledge and foreseeability, etc. These things all have to work in tandem, as we'll discuss in a moment when we come to the practical takeaways. And you'll see the third bullet here: a plaintiff, injury to the plaintiff will be reasonably foreseeable if the defendant should have reasonably foreseen that the plaintiff would rely on the representation and that the reliance would be reasonable. And if we go to the next, page, and then you'll see what I just said about the policy considerations. These principles at the second stage of the ANS test such as knowledge of identity or class, and whether the reliance losses were directly linked to the purpose, are no longer considered at the second stage. They are now part of the first at the first stage. And so what happened now in that Livent case, just to make you maybe think about this a little bit. So there's a long history, but basically Messrs. Drabinsky and Gottlieb had two sets of books. They showed one set to the auditors and didn't show them the real set. They invested or attracted lots of investment over the years, and the whole thing, of course, fell apart when somebody discovered that there had been a massive fraud. And there were two complaints in the case about the auditor's conduct. The first was that the auditors were acting as advisors to the company in soliciting investments. And applying this test, the court found that there was a duty of care, but later reduced the damages. The second piece was that the auditor had conducted a statutory audit. Well, you would have, on the basis of Hercules, which the Supreme Court affirmed in this decision, you would have concluded, reasonably, I would have said that there would be no damages recoverable on the theory that had been presented, which was that the company was losing money throughout. And had the auditor done a proper audit, it would have been discovered that management was basically falsifying the accounts, and the company's losses would have stopped there. But instead, they were continuing to incur. The company was continuing to incur losses, and that affected the shareholders or investors' investments. Deepening insolvency was the theory that was discussed at length. The Supreme Court found that the auditor exposed Livent to reasonably foreseeable risks, including business losses, that would have been avoided with a proper audit. Indeed, the risk of injury flowing from undetected fraud is precisely, and they underlined the word precisely in paragraph 65 of the Supreme Court decision, precisely the type of injury statutory audits seek to avoid. And I'm going to submit to you that that is not what they wrote in 1997 in Hercules, nor is it what the House of Lords wrote in 1990 in the Caparo case. So this is how we've evolved. Real quick, if we go to the last slide in this, there's been a couple of recent cases, no real surprises. You've probably heard of these cases, but in both instances, looking at the purpose for which the opinion was prepared and the use to which it was put, it was found that there was no duty of care. So I would say Livent changed the landscape dramatically, and we should talk, and I think we will now, Sarah, maybe about the takeaways. But you can see it's a very complicated and complex area of the law that deals both with duty of care and risk considerations and also damages. And Sarah, maybe I'll just hand the mic back to you for a moment.
For sure. Thank you very much, Michael, for that. That was amazing. But I would like to take some practical commentary now, and I'd like to open it up to the panel. So Deepshika and Krista, I'm going to call on you after Mike. But Mike, if I could have you start on the following question. What would you recommend auditors and accounting professionals do in light of the current state of the law to better protect themselves from liability? And if you could maybe start with that.
Sure. And let me say this, my experience with the accounting firms that we deal with is that they have adapted very quickly and very well to this new regime. They have enhanced risk intake measures where, the biggest risk is fraud, right? And so fraud will almost inevitably go undetected in the majority of cases. And so that's always the risk that's out there. So the intake procedures that I've seen and that are reflected in various types of audit working papers have really improved dramatically since the days of Livent and also the Phillip case, if folks are familiar with that. If we just flip, maybe there's a checklist that we noodled over, and I want to talk just about the first five. So the biggest source of protection that an auditor or an accounting firm undertaking a professional mandate can establish is in the form of the engagement letter. And again, the engagement letters that we've actually advised various accounting firms on what should be in their engagement letters as the law has evolved, as I've just described in the last 20 years at least. Obviously, these are all interrelated, but knowing who exactly the client is may sound like a bit of a motherhood statement, but it's really important because the starting point is, first of all, tort and breach of contract create concurrent liabilities. And so the privity piece is who is the client? Because that informs in large part to whom the duty is owed in the first place. Nobody would have doubted that Deloitte, qua auditor, qua statutory auditor, owed Livent a duty, just like Ernst & Young owed one to Hercules Managements. But you have to identify that so that there's no ambiguity. And then you get into the different layers. Who is going to receive the opinion? Is it the company? Is it the shareholders? Is it the collectivity of shareholders? Is it a statutory opinion? So these things should be set out. Who will use the opinion? So there are restrictions on use terms that I've seen that are well designed to protect the auditor from the client taking the opinion and handing it to the friendly bank for a $10 billion loan. Well, if the engagement letter says you can't do that without my consent in writing, that goes a long way to limiting the use to which the bank can put that audit opinion, at least for purposes of liability. What purpose? So the purpose is probably the most critical element of the engagement letter, and I've seen engagement letters that go on and on and on and explain. And remember, the purpose can change. So you have to be careful that the auditor is always given an opportunity in the first engagement letter to control the purpose. The company might receive a statutory audit on day one, and on day 200, give it to an investor or a bank. Has the auditor consented, acquiesced, somehow approved of that? The letter should address these circumstances. And that kind of talks about 5 as well. So these all deal with the duty, the scope of the duty, and the new Livent test with respect to foreseeability and proximity. That's what these things are all designed to limit.
That's great, Mike. Deepshika, if I could maybe turn to you, could you provide some input on what considerations in relation to fees and limitation on liability should be considered when drafting the engagement letter?
Yes, thank you, Sarah. One of the other things to consider in your engagement letter is a limitation of liability clause. Limitation of liability clauses are instituted for the purposes of not only limiting the type of liability you may incur, but also the damages that you may incur in case of a claim, a lawsuit, or an action against you resulting from that engagement. One of the recent cases that talks about how a limitation of liability clause was actually held up in practice and treated by the courts was the Rink Consulting Inc. case versus Grant Thornton. Now, in this case, Rouston, who was a shareholder, engaged Grant Thornton. He was a shareholder of PSG, which is a manufacturer and distributor of hockey goods. And Rouston wanted Grant Thornton to do a survey because he disagreed with PSG's latest transaction, which it was going to enter into the retail market along with distributing to its major retailers. Grant Thornton was tasked with conducting a survey of its major retailers. And then Rouston's hope was that once he distributed that survey to the board of directors would be discouraged from entering into that transaction, and also wanted to be part of the board, which would serve his ultimate purpose. Grant Thornton had three important clauses in its engagement letter. One was a reputational clause, which basically said that Grant Thornton could cease the engagement at any time if it felt that it would impact its reputation. The second was a termination clause, which provided Grant Thornton the ability to terminate the engagement if it so reached a conclusion based on either reputational risk or otherwise. And third was a limitation of liability clause. The limitation of liability clause had two paragraphs in it. One which said that Grant Thornton's liability would be limited to its several share of negligence only. So if multiple parties are sued, Grant Thornton's share of damages, if it was found liable, would be limited to its several share of liability. And the second paragraph was that in any event, the damages would be capped at whatever Grant Thornton earned from the engagement. And we see this type of a limitation of liability clause where accounting firms cap their damages or their liability to the professional fees that they get from the engagement. Now, the court considered this and determined that the limitation of liability clause in this circumstance could not uphold because the purpose for which the limitation of liability clause was drafted was to prevent from third-party lawsuits and actions, and not the situation where Grant Thornton was the entity that had terminated the contract, which was a first-party transaction between Grant Thornton and its client. And so that breach of contract was not covered by the limitation of liability clause. If a third party had sued Grant Thornton and the client, that circumstance would be covered by the limitation of liability clause. And that sort of leads us to four practical considerations that I think you should keep in mind when you're drafting these limitation of liability clauses. Number one, make sure that all of the causes of actions that you want your limitation of liability clause to cover are properly addressed. Number two, make sure that any limitations that you put on how the damages will be calculated, whether it is the professional fees returned, whether it is a percentage of that, or any other mechanism, is clear, because your limitation of liability clause, which is an exclusionary clause, should be clear to your client who's going to read and sign that engagement letter. You cannot exclude things like fraud or regulated activities from your limitation of liability clauses. So you can't say, well, if we commit a fraud, our liability is limited. That will not uphold. So make sure that your limitation of liability clauses properly address the issues that you're trying to cover through it. And lastly, draw specific attention of your client to that clause so that if you are in a court of law, it is very persuasive if there is a special initial against the limitation of liability clause, or there is a special recorded term that says the limitation of liability clause was discussed, because that shows intention and clarity that ultimately the courts rely upon in enforcing these clauses. So those are some of the things to consider when drafting your limitation of liability clause. I'll turn it over to you, Sarah, for the next.
Perfect. And Christy, if I could call on you to address the last element when considering engagement letters and how the consideration of possible private arbitration could work to avoid reputational risk.
Sure. So, when you are drafting these engagement letters, certainly considering private arbitration, to avoid reputational risk can be a key consideration. Frequently, audit disputes are going to involve fairly sensitive issues, particularly if there is a concern about misstatements in financial statements and a root cause of that. So if those issues have to be litigated in public, certainly there is the potential for significant reputational risk. Of course, there's many other benefits to arbitration other than the benefits to having a more private forum to litigate a dispute, including being able to choose an arbitrator with subject matter expertise, streamlining of various discovery processes, more active case management, those kinds of things. Sometimes there can be issues around whether or not an arbitration clause is permitted in a given regulatory regime, particularly in the States. But generally speaking, it is something that should be given strong consideration to when you're preparing your engagement letter.
Perfect. Thank you so much, Christy. And Christy, if you can hang tight, because I'd like to change our focus a little bit now, and I'd like to talk about regulatory risks. So, Christy, if I could ask you to walk through the regulatory process and the various powers within that. And secondly, if you could provide our audience with some tips and practice points that you can provide on how to manage these types of regulatory matters as well.
Sure. So one of the ways we talked a lot about civil liability to date, and one of the ways in which accountants can face a different kind of risk is really through the regulatory process and with respect to their professional regulatory body. So in Canada, the regulation of the accounting profession and CPAs is primarily provincial. And so every province is going to have their own regulator granting the CPA designation and also have their specific governing documents and legislation. So I'm based in Alberta, and as an example, CPA Alberta is going to be the professional regulatory body for CPAs in Alberta. And their governing legislation is going to be things like the Chartered Professional Accountants Act, the regulations and the bylaws that are published by CPA Alberta, as well as any rules of professional conduct. It's going to look similar across the provinces. So for example, Ontario is going to have the Chartered Professional Accountants of Ontario Act, their regulations and bylaws, their rules of professional conduct, and also specific rules and procedures that they have related to the conduct of hearings before administrative tribunals. So we will, in the presentation, touch a little bit later on this issue of parallel proceedings and the idea that you can actually have both a regulatory and a civil risk. And they are distinct issues, but they do have the ability to impact on one another. And so it's very important to be aware of those two processes when you are defending whether that be on the civil side or on the regulatory side. Generally speaking, with the regulatory bodies, the complainant is not going to be receiving financial compensation or damages. The parties in these regulatory disputes are going to be your professional conduct committee, your complaints inquiry committee, and the registrant who is the subject of the complaint. And the real regulatory focus and the focus across these statutes and what the CPA bodies are really concerned with is protecting the public interest, ensuring the integrity of the profession, and enforcing the practice standards. So it's obviously quite a different focus than what you might be looking at when you're dealing with a civil complaint or a civil claim, for example. So when we look at the complaint and the discipline process, Again, every provincial regulator is going to have their own process that they have detailed in their specific governing documents for handling of the complaint. And generally speaking, that's going to be a tiered process. So thankfully, not every complaint is going to make its way down the pipeline to a disciplinary hearing. There's going to be a review at various stages along the way to determine if the complaint is something that should be dismissed at first instance, whether it's something that is too minor to warrant a sanction, perhaps whether there is further investigation that needs to be conducted, or whether in fact it is something that needs to proceed to a disciplinary hearing. And in the course of investigating these kinds of complaints, there are, generally speaking, very broad powers that are afforded, whether that is to a complaints inquiry committee or to an investigator, to look into the facts or the substance of the allegations that have been made in the complaint. So, for example, if you are an investigator under one of these pieces of legislation, you are able to compel document production. You are able to interview a complainant, a registrant, anybody else who might have some relevant information that you feel is relevant to investigating the complaint. And you may also you might not just be limited to the complainant and the registrant, but anybody else who might seem to have information about the complaint. And you're not just necessarily limited to what the complaint is actually about, but if in the course of the investigation, something comes to your attention about some other questionable conduct, there can be the power to look into that as well. So it is a very broad investigatory power that is afforded under these various, or that can be afforded under these various provincial governing documents. And if you don't comply, there are provisions as well in the legislation for compelling that compliance, whether that is through fines that can be imposed, or whether that is through a specific process that the regulator can undertake to get a court order requiring that compliance. So our goal as counsel, if we get involved, if a complaint comes to our attention, is really to ensure that it's nipped in the bud as quickly as possible. It's not one of those things where we treat it as sort of a preliminary stage inquiry and make perhaps a half-baked response to it. We really want to get as fulsome a response as possible right at the outset, to show whether it be the complaints inquiry committee or a professional conduct committee that the complaint does not warrant further investigation or a disciplinary review. You really don't want to get further down that process. So that is the best possible outcome, is to nip it straight in the bud. So when you get a complaint that comes in, generally speaking, it's going to go through a complaints inquiry committee, an investigation committee, or something of that nature before the provincial regulator. They will be looking at whether or not there is jurisdiction to hear the complaint. And by that, I mean, sometimes there's a lot of complaints that might come to their attention that the regulator has no jurisdiction to deal with, or that there's been a question in the past about whether they have the jurisdiction to deal with. Such as, for example, things in a professional's personal life can regulate private conduct, would be an example of something where there's a jurisdictional question. Certainly, what constitutes unprofessional conduct can be very broadly defined in these pieces of professional legislation. And there is case law to the effect that albeit that there are actions in your private life that can also constitute unprofessional conduct in your profession. Certainly in Ontario, there are specific provisions that the Professional Conduct Committee does have jurisdiction over complaints, regardless of whether or not that conduct that's being complained of was in the course of your activities as a chartered professional accountant. So once the committee has reviewed the complaint, they've determined that they have jurisdiction and they've investigated the complaint. As I say, they may choose to do nothing. They may choose that perhaps further guidance is warranted. They may choose that further investigation, they may recommend, I should say, that further investigation is warranted. or they may proceed straight through to recommending that there be a disciplinary process that happens. The legislation will specify in the various provinces whether or not there are rights of appeal. So certainly the provinces will differ on this issue in terms of where and when and how and on what questions you can appeal, including what the potential standard of review is. And so ultimately, if the matter, for example, in Alberta, if a complaint is dismissed, you do have the right to appeal that. The complainant does have the right to appeal that decision, and there's a whole appeal process that's set out in the legislation and the governing documents for what that looks like. If the matter does get referred on, and unfortunately does make its way to a disciplinary tribunal, then of course there's going to be a disciplinary tribunal convened that is going to hear the evidence and make a determination on whether or not there has been unprofessional conduct that's been made out and what the sanction on that should be. Now, of course, when you look at there's a large volume of practices and procedures that can accompany the disciplinary tribunals work. For example, in Ontario, there's a number of regulations dealing with the jurisdiction and the powers of the discipline committee and rules of practice and procedure around what that looks like. But the rules of evidence is one area that's also one that you should pay particular attention to. And rules of evidence generally tend to be more relaxed in front of the disciplinary tribunals. So they can review, or they have the ability to, they're not bound by the ordinary rules of evidence. And they have the ability to consider any evidence that they believe is relevant to the determination, including potentially evidence from a prior proceeding. So there are specific rules, for example, in Ontario, where the committee may be, the discipline tribunal may be permitted to consider evidence that was submitted and accepted in a prior proceeding, including in a prior court proceeding. So once the disciplinary hearing is underway, and once a determination has been made as to whether or not there's been a professional conduct, and if so, what the sanction is, then, as I mentioned, there can be certain rights of appeal flowing from that. And that is an important thing to keep in mind, because certainly the legislation is going to specify the scope of the appeal, what questions can be appealed, whether new evidence can be admitted on appeal, and even whether or not the decision of any appeal tribunal is final. So, for example, in Alberta, a disciplinary matter can be referred on to an appeal tribunal and then to an appellate court. In Ontario, if you do appeal a decision of a decision tribunal, then to the appeal tribunal, it circumscribes the particular questions that the appeal tribunal can review as being questions of law or mixed fact and law, and their decision is final. So maybe with that, we can turn over then to the next slide, which is the Chartered Professional Accountants of Alberta versus Matheson case. This case is an interesting one. It's an interesting one because it's a recent decision coming out of the Court of Appeal. It's a split decision. And it really deals with this whole issue surrounding standards of review. Not only standards of review that are internal, so standards of review from a discipline tribunal to an appeal tribunal, but also an external standard of review. So from an appeal tribunal to a court. And it reaffirms the ways in which courts will, the level of deference, I guess I should say, as a standard of review that should be afforded to various findings. Of course, findings of fact will be accorded significant deference. Decisions on sanction are things that are viewed as questions of mixed law and fact, and that should also be viewed as whether or not they were reasonable. And it's also a decision that was made post-Vavilov, Vavilov being the seminal decision on standards of review. So it is a helpful case from that perspective, but there's also a lot of good commentary on it in relation to parallel proceedings, and sometimes how much credibility should be given to witnesses in regulatory proceedings when you do have a parallel civil proceeding or the potential for one. And so very briefly, in this case, there was a CPA who was the CFO of his company called CPP. And ultimately, the CFO was terminated for cause. And a complaint was brought against him to his professional regulator, the CPA Alberta, for the misappropriation of funds to his personal account. And ultimately, he was found to be guilty of unprofessional conduct, and a sanction was imposed on him of a 2-year suspension of his registration. That decision got appealed, and in fact, the appeal tribunal ended up increasing the sanction on him to a complete cancellation of his registration. When that decision was appealed to the Alberta Court of Appeal, the Alberta Court of Appeal did not overturn a finding of unprofessional conduct, but they did overturn the sanction. And in doing so, they noted that the appeal tribunal had incorrectly suggested that the discipline tribunal had somehow limited its discretion. And the Alberta Court of Appeal also noted that the appeal tribunal had found that there was an intentional and wrongful taking of the money, and the Alberta Court of Appeal said such a finding was basically not borne out on the facts that the discipline tribunal had found, and the appeal tribunal was not entitled to make that finding based on the findings of fact that were made by the discipline tribunal. So they reinstated the decision of the discipline tribunal. There was a very strong dissent in this decision, and the dissent really commented on the motives of the complainant in bringing the complaint. In this particular case, the complainant was the CEO of the company that had fired the CPA. And the CEO admitted that he was motivated to bring this complaint to CPA Alberta because he thought it would be helpful to him and to his company in any sort of action for wrongful dismissal. He thought a finding by CPA Alberta would be helpful in that regard. And so the dissent was quite strong in saying that, that in this case, it was Justice Wakeling. He did not feel that adequate consideration had been given, or any consideration had been given by the discipline tribunal in considering the motivations and the partiality of this particular witness, that he was the star witness of the prosecution in this case, that without his evidence, there was no case, and that the discipline tribunal did not give appropriate regard to that issue of partiality of the witness. And in this case, he said no sanction should have been imposed. So again, that was a dissenting opinion, not the majority. The majority did not find that to be the case, but a very helpful decision when considering this issue of parallel proceedings and the extent to which one could use this issue of partiality of a witness to challenge credibility.
Christy, if I could just interrupt you really quickly, we're just getting a little short on time. So
Sure.
if you wouldn't mind addressing the practice points kind of quickly, and just that way we can ensure that we get to our final points for the audience.
Absolutely. And so very quickly on some of the practice points when you're responding to a complaint, you always want to take a cooperative approach and transparent approach to dealing with the regulator. And what I mean by that is they already have extremely broad powers to investigate their complaints. And a key focus of theirs is protecting the public interest. If there is a bad fact of yours that you have, for example, if a mistake has been made, you should give some consideration to admitting that there was an issue that was made. Again, speaking in generalities, you certainly don't want to make any admissions that could potentially impact on you as far as a negligence claim is concerned. But if there was an error, in fact, that happened, there can be value in considering whether it is best to simply admit the error that happened. And there's ways to diffuse that. So if there was an error that happened, and if it's determined that it's you can acknowledge that error without prejudicing yourself in the context of a civil complaint. How has that error been dealt with? What practices have been put in place to minimize that happening again? Has there been any training on that issue? All of those things can help show the regulator that this is not an individual from whom the public needs to be protected, or that this is not a systemic issue that the regulator needs to get involved in further. Litigation holds are key. Preservation of records is key. And again, one of the things that you really need to do right out of the gate with these kinds of things is to address the complaint as fulsomely as you can. You want to ensure that you are providing the most fulsome response so that there's no lingering questions left in the mind of the investigator when they're wondering, well, do I need to order a further investigation? Do I need to look into this matter further? And then you wish, oh, I wish I would have provided a more substantive response at the outset. Or maybe I need to change my response because additional information has come to light. You don't want to do that. So be as fulsome as you can right at the outset. As I mentioned before, nipping it in the bud at the investigation stage is key. With that, maybe I will turn it back over to you, Sarah. I know we're running short
Perfect.
of time.
So Deepshika, I'm going to turn it over to you briefly. And if you could maybe just give a brief synopsis, because I think it's important, on the evolution of the law of the equitable remedy of rectification and a brief overview of where things stand now based on recent decisions from the Ontario Court of Appeal.
Yes, thank you, Sarah. So the doctrine of rectification is an equitable doctrine, and what it really is meant to address is a situation where your written contract has certain terms and agreements in place which may not then be effective in your actual practice of a transaction. Now, in the tax context, this generally means you may have an agreement in place to structure a transaction in a certain way, but in practice, when you structure that transaction, it may lead to tax consequences that were not intended as a result of that transaction. Most commonly in those situations, the doctrine of rectification is one that can be relied upon to rectify those underlying documents. The history of rectification is really started from the case of Juliar, which said that if you had an unintended tax consequence, you could go back and retroactively rectify your documents to ensure that the tax consequence could be neutralized if that was the initial intention of the parties that was documented. So keep in mind that it talked about the intention. Skipping forward to today, the leading case on this issue is the Fairmont case. The Fairmont case essentially overturned that doctrine and the intention piece as part of that doctrine. What the Fairmont case said was you can still rely on the equitable doctrine of rectification, but only if your agreement that was put into place clearly reflects how the transaction is to be structured, and if the transaction is not structured in that manner. It does not matter whether you intended that the transaction would have no tax consequences. If in fact the structure was done in the way that it was written in the agreement, that is what would be enforced. However, if your transaction was not implemented in the way it was written, then you could go back and rely on the doctrine of rectification to change that. And that is what the Fairmont case really talks about. If you can go to the next slide, Kate. So that came out of Fairmont and has really what has been in practice since then. I'm going to briefly talk about the Pius real estate case, which basically involves 4 corporations which were horizontally structured. The intention was that the ultimate shareholder would get tax-free money out of these corporations. But when structuring the transaction, the accountants didn't take into account that one of the holdcos in the horizontal structure had a capital deficit account. Now, because it had a capital deficit, what happened was the tax consequences that would result from that would not result in a tax-free dividend to be paid to the shareholder. They brought a rectification application to fix that. The Court of Appeal, the underlying court first, granted that rectification, saying that the intention was always to have a tax neutral consequence. The Court of Appeal overturned that and reminded the lower court that the intention was not what was relevant. The agreements talked about $1.4 million being given to the shareholder. The transaction was structured to give $1.4 million to the shareholder. The fact that they missed the capital deficit and that resulted in a tax consequence was irrelevant. The agreement and the implementation were the same. If you go to the next slide, the case of that doesn't mean that rectification is gone. So just on the other side of this, the court allowed a rectification of the shareholders register, which had the holdco listed as the shareholder in a transaction. And because the holdco was written as the shareholder, it meant that the shareholders individually would be dinged with tax consequences. Now, the court said in this case, you can rely on rectification, but because the underlying memorandum talked about the individuals being referenced as shareholders, and the holdco would be listed as a shareholder, and therefore the court allowed the rectification of the shareholder register to replace the individuals with the holdco, and therefore resulting in a tax neutral situation. So in summary, to keep in mind, I think for rectification cases, you should document your agreement, make sure that your agreement lists out clearly the intention of the parties, because it will not matter whether the objective was a tax-free situation. If your transaction does not clearly identify how it is to be structured, you will not be able to rely upon and say, well, someone made a mistake or someone made an error, and therefore the transaction needs to be rectified. Documentation is key in these situations. And so document each step, implement each step, discuss the impact of those before you implement the transaction, because that is ultimately what you can rely upon for rectification. And with that, sir, I'm going to turn back to you so that we can wrap up with some discussion.
Perfect. So we've got one last topic, and I know we may run over a bit, so I just asked the panel to be cognizant of that we be brief, but I think it's important. So thank you to our audience for giving us a little bit of leeway. I'd like to raise the panel, and Mike, I'm going to call on you first, but I would like you to provide your insight on the risks of parallel proceedings when you have the civil and the regulatory intersecting. So Mike, can I start with you and then over to Deepshika and Christy, but please keep it brief. I'm sensitive to our audience being a bit tight on time.
Yeah, and that's something that we've run into in a number of cases. Imagine you've got CCAA proceedings, you've got civil proceedings in one province, you've got civil proceedings in another province, you've got institute proceedings, discipline proceedings, the nature of which that Christy just described. You've got a shareholder class action in the United States. You get the point. You have to be fully coordinated, and I didn't just make that up. That, for example, is what happened in the Philip Services litigation and in the Livent litigation. And the trick if you're on the receiving end, which you are as the accountant in this piece, you have to manage the timing of matters so that you're not giving the plaintiff in the civil action where the money is at stake, which is where all the risk is really. You don't want to give them a strategic advantage by allowing them to see information that they wouldn't ordinarily get through the usual disclosure regime. So managing that is really important. We could do a webinar just on that. So I'll just stop because it's now 1 minute past the hour. There were a few questions, by the way, from the audience.
Yep. Deepshika and Christy, is Mike's summary good enough, or do you have anything you'd like to add?
I'd just say keep in mind your documentary production issues. Think of if you can use different jurisdictions, as Mike said, if it is in the US, maybe you want to take a stab at staying one of those proceedings in advantage of the other and the strategic impacts of that. And ultimately, obviously, where you want to allocate most of your costs and resources. As Mike said, civil proceeding is really where the money is. So you want to make sure that you're allocating proper resources and costs to that.
Christy, any last comments on that issue before we move on to our Q&A?
One last thing, if you've got different sets of counsel representing you in civil and regulatory proceedings, make sure you've got coordination so everybody is singing from the same songbook and you're not taking conflicting positions in different pieces.
Great. So I'm just going to move to the Q&A session. So thank you to those who have put questions in the chat. And for my panel, we have one other key question, and any of you can address this. And the question was whether our comments on engagement letters are also applicable to auditors in the province of Quebec. Are any of you able to answer that issue?
I'm not wearing a Quebec call to the bar medal around my neck. I'm a little reluctant to respond to the question, other than to say this. I am familiar with auditor liability cases out of Quebec. The Widderingham Estate case, I think, is one that comes to mind. And the principles in the Quebec Code and at common law are very much aligned. And so I would think the only restriction would be a regulatory restriction from Quebec with respect to what you can put into engagement letters. And also, and this will apply across the board, for example, when you're dealing with engagements that are subject to SEC oversight, for example, public companies in the United States, for example, don't allow arbitration clauses the last time I checked. So you just have to be careful and really consult with the local legal advisors to make sure that what you're putting into your letter is enforceable. But you can also, of course, always try to put in as much as you can with a good severability clause.
Perfect. And Deep, I've got a question that I'm going to turn over to you. So on the issue of rectification, the question is, if you document the tax consequence intentions on paper, would courts grant rectification in that instance?
Intention is still up in the air, I would say. You can record your intention to say, I want a tax neutral benefit out of this transaction, but ultimately you cannot implement that intention if your transaction has been structured in the way that it was intended to be structured. So for example, in that Pius case, the transaction was structured as it was meant to be structured and agreed to be structured by the parties. The fact that you may miss something and you may want a tax neutral consequence, maybe you haven't thought about things while structuring that transaction. You can record your intention. It'll be helpful in making an argument, but nonetheless, intention is not one of the criterias which will lead to you getting rectification. Justice Abella, who wrote the dissent in Fairmont, sort of warned against that and said, we're narrowing rectification to such an extent that the intention and the unintended consequences sometimes may not be fully understood at the transaction stage, even though your intention may be tax neutral. But unfortunately, the majority disagreed. And the majority said what is important is the documentation of the steps of the transaction and then implementation of those steps. What consequences may result from that is not what is relevant for the purposes of seeking rectification.
Perfect. Thank you, Deep. And because we are short on time, thank you to our audience for us going a few minutes over. And I want to thank everybody for joining us today and for engaging in this really important discussion. We hope you found the insights valuable and applicable to your work. If any of you do have follow-up questions or you would like to discuss how these issues impact you or your organization, please do not hesitate to reach out to any of today's speakers or to your Denton's contact. Thanks again for joining us and have a great day.